specific plans for post-divorce parenting. So parents, I would submit, are the most knowledgeable about their children's needs and interests. In cases where parents are in dispute over living arrangements after separation, it's important to children's well-being to establish the nature of each parent's desires regarding future commitment to raising their children, to determine from the perspective of each of their parents what is their parenting plan. That would include the degree to which each parent is willing to make accommodations to the needs of children, and the extent to which each is able to adjust his or her employment and living arrangements to allow enough time and energy for their parenting responsibilities. That's sort of one consideration. A second important consideration is parents' relationship history with their children. The time and the effort each parent has already invested in child caregiving before separation in the two-parent family is a second key element in regard to children's needs and interests. How involved and available and attached and attuned is each parent to his or her children's needs. In the interests of stability and continuity in children's lives, a parenting arrangement that approximates as closely as possible existing parent-child relationships is important to children's well-being. Thirdly, there is just children's need for both parents in their lives, just apart from the pre-divorce arrangements. Parents both actively involved. Research is clear that a shared parenting arrangement best assures the continued meaningful involvement of both parents, a vital component of children's well-being. And finally, children's need to be shielded from family violence and child abuse. It's vitally important that allegations of family violence and abuse be fully and quickly investigated and children protected from violence and abuse. So the shared parenting presumption, legal presumption I'd like to present to you, incorporates these four elements. It is, first and foremost, a child-focused framework that takes on board not only empirical research findings on the needs and best interests of children, but also the primary concerns of parent advocacy groups, the main concerns of both women's rights and fathers' rights groups. Second, the framework merges a rebuttable legal presumption of equal parenting responsibility with a rebuttable presumption against equal parenting responsibility in cases of established family violence and child abuse. So fathers and shared parenting organizations really advocate for this notion of a rebuttable legal presumption in favor. But many of the feminist organizations are calling for a rebuttable presumption against shared parenting in cases of family violence. If you think about it, the two are not incompatible, they're actually complementary. Because a rebuttable presumption in favor of shared parenting is rebuttable in cases of family violence, whereas a rebuttable, it's the same as a rebuttable presumption against shared parenting in cases of family violence. Thirdly, this framework confronts the problem of discrimination against children of divorce on the basis of parental status, which is what we have today. This is contrary to Article 2 of the UN Convention on the Rights of the Child, the non-discrimination clause, which spells out any number of factors whereby children can be discriminated on the basis of race, ethnic status, gender, etc., but also on the basis of parental status. And what we have in our present framework is a very different approach in regard to removing children from parents' lives into parent families. The criterion is that the child is in need of protection. It's a child protection issue, whereas in the case of family law, separated children, the criterion is the vague, indeterminate, biased, best interest of the child standard, And we talk about judges removing, we talk about judges granting custody to one or the other parent, or primary residence to one parent. In fact, the court removes a parent from a child's life. That's what really is what's happening. And that is contrary to the UN Convention, Article 2, as they use one very stringent criterion for children in two-parent families, but a discretionary standard for children of separation. So this framework addresses that. It provides for a consistent approach for all children. Fourthly, it transcends the subjectivity of the discretionary best interest standard, while at the same time taking into account children and families' individual and unique circumstances. So let me move into the framework itself, what I refer to as the 4 pillars of legal determination of parenting after divorce, a legal presumption of equal parenting as a form of shared parenting. And I referred to this framework as a 4-pillar approach. It's actually partly based on Canada's 4-pillar approach in the field of drug policy, which emphasizes harm reduction. It's been in place in Vancouver since 2003, and as I say, applied in the field of illicit drug law and policy. As I mentioned, Portugal has adopted many elements of this approach in reforming its drug laws, which are considered to be among the more progressive and enlightened in the world. I propose that this framework can also be applied to other areas of socio-legal policy, such as family law. The 4-pillar framework being, number 1, harm reduction, secondly, treatment, thirdly, prevention, and fourthly, enforcement. And this is what it looks like. So the first pillar, the main one, I would say, I refer to, I'm borrowing the language of Vancouver's 4-pillar approach to drug policy. The first pillar is that of harm reduction. And I would suggest that the best way to reduce harm to children and families undergoing separation and divorce is a legal presumption of shared parenting. The second pillar is that of treatment, which encompasses a wide range of activities, divorce education programs, family mediation, and support and intervention in high conflict cases. The third pillar is that of prevention, which is shared parenting, public education, and finally enforcement, and that involves enforcement of parenting orders, but also judicial determination of cases where it's been established that abuse and violence are occurring and children's safety is at risk. So I'll look at each of these pillars in order. The first one being a legal presumption of equal parenting. The harm reduction pillar. So this first pillar is itself comprised of 4 stages. And I'll spend a little bit more time on this one as it's a little bit more involved. And I'm drawing upon what different jurisdictions around the world are already doing and have been shown to be effective to some degree. So the first stage, I guess, in parental divorce is a legal requirement that parents develop a co-parenting plan before any hearing is held on the matter of parenting after divorce. So it's a legal expectation. The role of the court would be to legally sanction the negotiated parenting plan or agreement, whether it's a sole residential agreement, shared or equal. Parents are expected to come to an agreement before they arrive in court. It's a legal expectation. This is the standard in the United States, in Washington State, which is just down the road from Vancouver. And here, parents would have a choice of developing the plan jointly through direct face-to-face negotiation, as many do today, or they could do it via legal negotiation, their respective lawyers, or through family mediation. And mediation services and family support services would be focused on assisting parents in the development of this parenting plan. So parents would not be required to negotiate face-to-face, but they'd be encouraged and supported to negotiate in the future, because as the plan evolves over time, that will be necessary. So this legal expectation would provide a very strong encouragement to parents to work out their own arrangements, with it being assumed that parents actually have the capacity and capability to resolve their dispute, rather than surrendering the decision-making to the court system. So it's a strengths-based approach. Parents would be acknowledged as the experts in regard to their children's best interests, as they jointly develop a parenting plan tailored to their children's ages and stages of development, tailored to their own schedules and their children's unique needs. So parental autonomy and self-determination in regard to parenting after divorce arrangements would become the cornerstone of family law. And I think many legal commentators would agree that's a very desirable state of affairs, that we encourage to the maximum degree possible parental self-determination. As I mentioned, Washington State has had this approach for many years, and overall the results have been quite positive. At the same time, there are many cases where this first step, the parenting plan approach, will not work. Parents just, despite their own best efforts and the help of neutral third parties or lawyer negotiation, they just can't come to an agreement. They're still locked in conflict. So where do you go from there? So when this first step is not successful, I'm suggesting we move now to the second step, and that is the legal application of the so-called approximation rule. When parents can't agree on a parenting plan, children would be expected to spend time with each parent after separation in the same proportion to the relative amount of time each parent devoted to childcare before divorce. So the state of Virginia has this in place. Noted divorce scholar Robert Emery, psychologist, is a very strong proponent. He claims to be against shared parenting, but this is a form of equal parenting in a sense, because the time that mothers and fathers spend with children after separation is equal to the time they spent before separation. So in cases of dispute, the approximation rule as the legal standard would base post-divorce parenting on the relative proportion of time children spent with each parent and the amount of time each parent spent performing child caregiving functions before the divorce, so that existing relationship would simply continue. If mothers were the primary caregivers, they would still be the primary caregivers, and vice versa, if fathers were. And if it's shared, it will continue to be shared. So as a form of equal parenting, the approximation rule is individualized, child-focused, and gender-neutral. It also provides judges with a very clear guideline. Children's needs regarding maintaining their existing relationships with each parent and stability and continuity in regard to their routines and living arrangements would be addressed. And parents' needs for a fair, gender-neutral standard would be also addressed. Now this approximation standard was drafted by feminist scholar Catherine Bartlett for the American Law Institute, and incorporates feminist concerns regarding primary parenting after separation. The argument being, if mothers were the primary caregivers and children were used to that, why would you disrupt that with shared parenting? But it also, in fact, addresses fathers' concerns regarding maintaining a meaningful relationship with their children after divorce. It also puts a little bit of onus on fathers. If they want to be sharing care of children after separation, the expectation is that they're already doing that before separation. Now, given what we know about child caregiving in two-parent families, and I can certainly speak to the North American context with some confidence, but also in Europe, there's a gender convergence occurring in regard to division of child care tasks. And shared parenting has emerged as the norm in two-parent families, shared care for children in two-parent families. There's been quite a... So the approximation criterion will translate to roughly equal time apportionment in most cases of disputed cases of parenting after divorce. Third step would be legal application of a rebuttable presumption of equal parenting time when both parents were primary caregivers or claimed to have been primary caregivers. So this would apply in cases where they were actually both equally involved, but also where they were both claiming to be primary caregivers that are in dispute over the relative proportion of time each parent spent performing child care before divorce. Because the preoccupation with and ongoing conflict over the amount of time spent with each parent is the main problem with the approximation standard, as illustrated in the case of Virginia, where this is in place. Tracking parental time is very complex, and litigation rates haven't really decreased in Virginia as a result. So parents will dispute each other's estimates of past time, with mathematizing time a focus of conflict. In the interest of shielding children from ongoing conflict, I'd suggest that equal time division should be the legal norm, not only in cases where both parents were primary caregivers, but also claimed to have been primary caregivers. So again, in addition to being child-focused and gender-neutral, this would provide judges with a clear guideline and avoid the problem of judges adjudicating or trying to decide how much time each parent spent in child care before separation. This presumption of equal parenting responsibility established an expectation that former partners are of equal status before the law in regard to rights and responsibilities, and sends that message to children that parents are equal value as parents. Okay, I'm having to skip a lot since I've been told I have only a few minutes, but I'm less than halfway through, so I'll try to get through it. The fourth pillar, or not the fourth pillar, but the fourth element of the first pillar is a presumption against equal parenting in cases where it's established that a child is in need of protection from a parent, where there are safety concerns, family violence, and abuse. It would develop clear guidelines for legal determination of parenting in substantiated family violence and abuse cases, consistent with those for children in two-parent families. Excuse me. With the safety of children as the primary consideration. This doesn't mean a presumption of no contact between the alleged perpetrator and child in cases where violence is alleged. Courts would only make protective orders when allegations are upheld, substantiated. So equal parenting would be rebuttable only in cases of family violence, and substantiated child abuse only with an investigated finding that a child is in need of protection is a judicial determination of sole custody justifiable. So this four-stage process is a highly individualized process, taking into account the unique circumstances and situation of each child and family. The second pillar is that of treatment, and I've mentioned sort of four areas of divorce education, given the current lack of information to divorcing families, about what to do, what to expect, services that might be available. Divorce education programs make this information available before any dispute resolution process. So parents would be oriented to the divorce process, the impact of divorce on children, mothers and fathers, and better prepared for negotiation. And the research tells us that they're much better able to keep the needs of children at the forefront of their negotiations if they have this kind of support service to begin with. It would also offer a means of diverting parents to mediation programs.